Good evening and hearty welcome to the honorable speakers today and listeners and friends. This is the concluding program of the year-long celebration on the occasion of 70 years of Indian Constitution. We inaugurated the program on 26th November 2019 with the inaugural speech by the General Secretary of the Asiatic Society, that is myself. The Asiatic Society, being the oldest center of learning and research in Asia since its foundation by Sir William Jones in 1784, has been pursuing major academic activities centering around the broad domain of history, science, and art from classical as well as modern context. The founder president, Sir William Jones himself, was a man of jurisprudence. Therefore, it is but relevant in our intellectual legacy to hold discussions on Indian Constitution. It is a common sense now that the Bharatiya Samvidhan, the Constitution of India, was adopted by the Constituent Assembly on 26 November 1949 and became effective on and from 26 January 1950. The Dominion of India became Republic of India. Our Constitution owes its source material, among others, to Government of India Act 1858, the Indian Council Acts 1861, 1892 and 1909, the Government of India Acts of 1919 and 1935. The total number of members of the Constituent Assembly was 389, which was reduced to 299 after the partition of India. And out of 299 members, 284 members signed the original document in English and Hindi. The original constitution was handwritten. Each page was decorated by artists from Shantiniketan, where Vishwabharati was established by Rabindranath Tagore. The artists included Nandalal Ghosh and Beuhar Ram Manohar Sinha. The calligraphy was done by Prem Bihari Narayan Raisda. The sessions of the Constituent Assembly started from its formation on 6th December 1946 and met for the last meeting on 24th January 1950. The objective resolution was presented by Jawaharlal Nehru on 13th December 1946 and adopted on 22nd January 1947, and this became the preamble of the Constitution. The Constitution has 470 articles, 25 parts, 12 schedules, 5 appendices. The words such as socialist, secular, integrity were added in the preamble through 42nd Amendment in 1976. The latest amendment was done through 104th Amendment on 25th January 2020. The date of adoption of the Constitution being 26th November 1949, the day is celebrated as the National Law Day, which commits itself to spread the importance of the Constitution along with the thoughts of its father figure, that is Dr. B.R. Ambedkar. This is also well known. The drafting committee of the Constitution was chaired by Dr. Ambedkar. There is no denial of the fact that among other members, the drafting committee, Dr. B.R. Ambedkar shouldered the lion's share in its completion, taking care of almost everything of the draft. He consulted the constitution of nearly 60 countries of the world in order to satisfy himself for every details. Friends, with this brief introduction, let me announce the names of the speakers of the discussion today, which will follow in this order. Professor Prasanta Ray, Professor Emeritus, Presidency College. Shri Subhash Dutta, Environmentalist and Social Activist. Dr. Satyajit Das Gupta, Associated with the Department of Women's Studies, Calcutta University, and Director, Postgraduate Diploma Course in Counseling, Legal Aid Services. So with this, I conclude my introductory note. With this brief introduction, now let me announce the names of the speakers of today's discussion, which will follow in the order I place. Professor Prasanta Ray, Professor Emeritus, Presidency College. Honorable Justice Pratap Kumar Ray, former Justice of Calcutta High Court and former Judicial Member, National Green Tribunal. Shri Subhash Dutta, Eminent Environmentalist and Social Activist. Dr. Satyajit Das Gupta from Legal Aid Services. So, thank you very, very much.
Good afternoon. This lecture, as you know, is in celebration of the Constitution Day in India. The lecture I now proceed to deliver has a brief title, The Indian Constitution Now. Constitutions, historically speaking, have been the brainchild of post-transition elite leading the movement for transition, which in our case was from colonial control to independence. The expression, "we the people," is usually invoked to lend it a popular representativeness. By common experience, such an elite, which composes a constitution after some deliberation among its members, usually comprises urban, educated, articulate middle class, which presumes that it has been mandated to act on behalf of the people. The people, as you know, is never a homogeneous aggregate and hence never has a uniform set of interests and ideological predispositions. Whoever is accustomed with the language, reasoning, and vision of an altered post-transition reality knows that for people not conversant with political and legal language and intent, it is difficult to comprehend the Indian Constitution. This could be true for people in other countries also. Its volume could also be a forbidding attempt for them. At a deeper level, they may not have figured out, the people, how its different provisions relate to their personal lives and entitlements. Thus, the Constitution has lived a mainly secluded life except for a few judicial judgments drawing on its provisions, which, according to some scholars, delivered Gandhian justice. It is possible that the idea of a constitution which enumerates citizenship entitlements has not reached people beyond urban India and into the periphery of the political society. This is true about independent India from its earliest phase. However, it appears that in recent times, the people, meaning those who do not usually engage with the Constitution, are developing an interest in this fundamental document. This has taken place in the context of the whittling down with the neoliberal turn in the last 20 years, whittling down of the proactive welfare state, of the policy of creating a socialistic pattern of society, and of violations of the directive principles of state policy, the soul of the Indian Constitution. Their keener interest now about the salience of the provisions in the Constitution is driven by their search for how to improve their quality of life, individual as well as collective, through claims making either at civil society initiative or through interest groups like trade unions or through political parties per se. Signs of these are public debates in the print and electronic media which foreground the Constitution, or in rallies with hand-held banners showing a facsimile of the Indian Constitution or of the preamble after 1976 42nd Amendment incorporating the expressions socialist, secular, and unity and integrity of India as the new transformative agenda. However, this turn to the Constitution has to be understood in the light of accumulating experience of denial of people's legitimate rights since the foundation of the post-independent state. Since the focus in this brief presentation is on people, the so-called masses, it may be relevant for us to recall that one leading member of the drafting committee of the Constituent Assembly once observed that the real test of any constitution was how it would play out in the hands of ordinary Indians. Conceding the ambiguity of ordinary, streets in Indian cities and towns in recent times have become spaces where the ordinary people debate the constitutional propriety of certain decisions of the ruling regime either at the national or provincial levels. This is the turmoil of the moment, when deliberations over the principles of constitution and procedures reverberate in street-level politics, much of which is party-led, but a conspicuous part is non-partisan, led both by revered political values codified in the preamble and by the raw emotion of fear of individual and collective loss of entitlements both as a citizen and as a human being. Popular discontent with the post-independent Indian regimes has always been present, but this time expressions of sectional restlessness have touched a new high and also coalesced into a social alliance. To them, the Constitution has become the only authentic political text to restrain rapacious regimes. That they celebrate the Constitution as a powerful inspiration for their legitimate claims making against the policies and practices of the regimes and the state suggests a grasp of the spirit of the Constitution and the laws, and also a readiness to inform their political interventions. But we need to remember that the people themselves are not above their petty interests, not above their malicious designs. So, it would be wrong to argue that it is the elite only which is responsible for the distortions in the Indian democratic system. Because after all, the leaders come out of the masses, and if the political quality or the moral quality of the masses are poor, then obviously we'll get to have leaders only of that particular mentality or frame of mind. So like any constitution anywhere, in mature democracies or in new democracies, the quality of the leaders and the masses turn out to be critical factors in making a constitution real, effective, in bringing about transformations. Because, as he said at the beginning, in all post-transition states of affair, the constitutions are actually the guidelines of the new society or new polity or a new kind of collective living. And as we celebrate the Constitution Day today, we need to remember that each one of us has to be politically and morally nearly perfect in order to have a quality leadership and in order to make the Constitution an operative document. Thank you.
Welcome, friends, my sisters and brothers. Today is the Constitution Day, and we are to celebrate that for adopting our Indian Constitution to the citizens of India. This is the environmental issue speech with reference to the constitutional provisions. After my working tenure as acting Chief Justice of Calcutta High Court, I was privileged to be the judicial member on merit of National Green Tribunal. This National Green Tribunal that was created by the statute, that is Environmental Protection Act and National Green Tribunal Constitution Act, and by these provisions the members of the National Green Tribunals, they were entitled to resolve the disputes relating to the environmental problems. While as a judge of this bench, sitting with another professor of university, expert member, we decided many cases, and amongst them the one was the construction of the guest house or tourist spot by the state government, that is state government of West Bengal, in Sundarban area in the Jharkhali. And this was a forest area, and this was the area for the habitat of the area concerned by the wild animals. Unfortunately, state government constructed a tourist bungalow and tourist house there for commercial purpose on violation of the restriction imposed for construction under the statute. A court directed the state government to demolish it and to make the area clear. But unfortunately it was not done. A contempt proceeding also was initiated against the then Chief Secretary of the Government of West Bengal. And ultimately the issue was not resolved as yet, and now the government is taking slow steps to comply with the order. But after I left the Green Tribunal, I do not know the present fate of that tourist building. The second interesting issue, as I decided, that is on the Environmental Protection Act, that is the brick fields. It is also the state of West Bengal. Here, so many brick fields were raised by the different members of different localities in complete violations of the environmental law. There was no environmental clearance taken from the Pollution Control Board, and even the government orders and circulars to that effect were not heeded. This was a very unfortunate situation, and there were so many cases of the brick fields and different area nearby to they constructed this brick field near the school, near the hospital, near the village, near the locality, and thereby polluted the area by burning the coal. The injunction orders passed, and all the brick fields which were illegal operation, were stopped, and penalty was imposed as a precautionary measures and preventive measures, so that they do not venture to violate the provisions of law. The third one which I dealt with is a very case of Tarapit. In the Tarapit, that is a sacred place of goddesses Ma Tara. There the cremation was being done in the open area, where so many tourists or so many devotees were present. And that was and also this burning also was causing the pollution. We directed the covering of the area so that that cremation ground is not visible in the public eye. Secondly, there should be an electric crematorium. Now it has been constructed as per the information by order as passed by us. In Tarapit also there was no suitable arrangement for water. People having no source of water at the area, we directed the concerned Panchayat or Development Authority, Tarapit Development Authority, to do that. They ultimately has done it. The Dwarka river, which was flowing by the side of the Tarapit, also was congested with the pollutants. The people used to throw, particularly devotees, used to throw the all waste materials thereon. Even the hotels which are existing at Tarapit, they also were not following the environmental law, the pollution, the air and water pollutions issue as per the statutes, namely Water Pollution Act and the Air Pollution Act. This matter was taken in a very hard way, and we passed the different orders of injunction restraining the continuation of those hotel and restaurants. So, and the Dwarka river also was restored to some extent of that area, though not fully. Another very important case is that was against the authority, who are the authority under Article 12 of the Constitution of India, relating to the thermal power station at Bakrishwar. And the area was ultimately this thermal power station of that area, they was polluting the entire area by the coal ash. And they are throwing it to the river. And these pollutants are passing through the entire fields. And there is destruction of the crops, and people also are suffering. We passed the order of injunction as the ash pond was not constructed or to accommodate all the ash as was coming out from these thermal power stations. Then they realized the issue as per our order, constructed further pond, and the river was made a pollution-free river by processing the issue scientifically. The another issue of the Bihar, that was at the Patna, on the bank of river Ganges, there was building construction by the promoters, and they constructed many buildings. We directed the demolition. So all these under the constitutional framework, exercising our power, being empowered under Article 21, Article 48A and Article 51A with Clause G of the Indian Constitution, and thereby the fundamental rights of the people of the clean environment, clean water, clean air were restored. The National Green Tribunal took the strong hand, even in the principal bench at Delhi. They are also deciding many cases accordingly. So this is the high time on the Constitution Day, we all to be united together to fight against the pollution, to make our living area as completely good habitation for the people, and also it should be for the next generation who will come, because it's an intergenerational doctrine, principle to be applied, and sustainable development to be considered as per the Rio de Janeiro conference held by the United Nations issue. But development does not mean destruction of the nature, to make the nature atmosphere full with pollution. We have to control it. Thank you very much, my friends, for hearing, for being us in that issue. Thank you.
Yes, today's topic is environment and the Indian Constitution. It's very interesting. Environment protects us, and the Constitution of India has attempted to protect the environment. So the subject matter is very encouraging and interesting for me. The environment has found its birth before the International Forum as back as in the year 1972, at the time of Stockholm Conference. So environment was figured as a very important issue considered by the UN. That was in the year 1972. But our constitution is 1950, 26th January. So our constitution is much older than the Stockholm Conference. What is the starting point of the environment before the International Forum? Our constitution has prescribed, there are two articles, Article 48A and Article 51A. Article 48A states that what is the responsibility of the state on the issues of environment. They have to protect the environment. It has given a specific mandate in our constitution. And it has given another very interesting mandate for us, for the common citizen, common people. It has cast a duty on the common people that they should try to protect the environment. So one article is for the state and the other article, Article 51A, is 51AG is for the people like us. So it is good. It is a good effort or endeavor of our constitutional procedure of the system, and several acts have been enacted. First is the Water Act 1974, then the Air Act 1981, Environment Protection Act 1986, and lastly there are in between several other very small acts are also there. But the NGT Act, National Green Tribunal Act 2010, National Green Tribunal Act has been framed to efficiently and effectively deal with the environmental issues of the country. It's equivalent to any state's high court. Since 2013, the NGT has started functioning. But there is one limitation of this NGT Act, because other than 7 and 8 acts, there is no jurisdiction of NGT. The jurisdiction of NGT should be made broadened. I hope, we believe that the constitution of our country or the system will kindly consider this aspect, that it should not be limited to only 7-8 acts. It should be broadened. And although the constitution has given these provisions, there are certain practical barriers. What has happened as an activist, I am neither here nor there. I am not a legal personality. So constitution also and the legal frames, certain things I know, but I don't know the whole thing. But what I have found, there is a barrier, because some people are there, they are experts in the environmental laws, and there are some people who are experts in the environmental sciences or environmental practices. So in one hand there are environmental laws, and on the other hand there are environmental experts, scientists. So the language of the law is not generally known to the experts, and what the experts know, some technicalities and practicalities, the legal people, they do not know. Because the purpose of framing the NGT Act is for expeditious and proper, timely disposal of the environmental issues and the problems. So in resolving that, in addressing this problem, it has been found that the legal personalities, the lawyers, counsels, even the judges, when they interact, when they submit or when they hear the matters, sometimes there are some technicalities which they do not understand. And the technical people, they do not understand the legal frames. The NGT is a combination of both, because in the NGT bench is there a principal bench and there are 4 regional benches. So there are legal experts, those who are practically at the apex in the legal practical forum, and there are experts, expert members, those who know the environment. And just one example I am giving, I was interacting with one Advocate General of a state. He was asking me that, Mr. Dutta, can you please elaborate that whether land includes the environment? Whether environment covers land also? Then I said, yes, it is there. So, and some people claim that in the transport sector, when we are agitating before the NGT and the High Court and the Supreme Court, the question came up that we should all go for eco-friendly or environment-friendly fuel for the transport sector. And some of the, even the judges, they claim that we should go for more and more for trams, claiming that tram is environment friendly. But it is not. Tram is operated by electricity, through electricity. For West Bengal, 97% of the power comes from thermal, which is the highly polluting and which causes the maximum pollution and global warming. So, tram is locally environment friendly, but not universal. So one has to understand that. So that way, National Green Tribunal is a good combination of the legal experts as well as the judicial experts. So it is doing very well, and in the environmental field, what we have found that it is not based on acts or laws. It is based on facts. So fact, how it can be better placed and elaborated before the judicial forum by visiting, not by searching through the Googles and internet. One has to visit that what is happening, and one has to study what should have happened. So one is the theoretical, another is the practical. So our constitution has given this elaborate right that the environment should be addressed both legally, practically, technically, scientifically. So, and there are one or two things what I have found our constitution or constitutional experts or the legal experts, that the judges' appointment, it is the retired persons, retired judges from the Supreme Court or the High Court, and the experts are also all retired persons, mostly. The appointment process of the judges should be like that, like the High Court or the Supreme Court. It is a better option not to take, because when a person retires, he may be wiser, but the level of efficiency and level of reflection may not be the same at the age of his tenure of service. So the process of recruitment of judges for the National Green Tribunal should be like the High Court. It is better. It is as a very close activist before the judicial forum. What I have felt. Another thing I have seen very recently, we have experienced that the NGT's order government violated, and afterwards the matter was moved to the Supreme Court. When the Supreme Court gave a direction, then everybody became very cautious and conscious, and they complied. So the punitive measures should be more stringent, more effective, and there should be some fear. In the CRPC and IPC, there are specific provisions that you have to face the penalty if you just commit an offense. But in the environmental law, there is only a blanket this amount of fine or penalty, and this amount of this quantum of the imprisonment. And the fine and penalty, what happens? The government has to pay, or somebody has to pay from one pocket to it goes to other pocket, not the individual. The NGT has directed some individual punishment, individual imposition of cost also or penalty, but it is not that way practiced. So I have a feeling that our constitution we are very much advancing, although we are a little slow, but we are steady. I am confident that our constitution, our laws and legal frames will protect the environment, which will protect all of us, everybody, including the lawmakers, including the judges, and everybody. So it is a good combination. We are progressing. And I am hopeful. I hope and trust that it will grow more and more. Thank you very much.
Let me begin by thanking the Asiatic Society for having me on this program. On a day such as this, paralegal functionaries like us will have a whole lot of things to say, but the time is rather short, and I shall try to be as brief as possible. What I've been asked to speak on, women, constitution, and the law, really stands at a kind of confluence of jurisprudential imperatives, social conditions, and political intentionalities. And it is this enmeshing of concerns and considerations that we need to ponder over on this very day. And let me also mention here that the observance of this Constitution Day in the US this year will also coincide with the celebration of women's right to vote, which uh, was given in 1920. So this is 100 years of that historic development also. And in our country as well, I think we should celebrate this particular historic development, because women of this country have been taking a very, very crucial role in an entire range of developmental and social activities. Um, um, I think on a day such as this, we need to think aloud and really think big, because I'm not getting into what we've been able to achieve in the field of constitutional law and lawmaking, etc., because I'm sure uh, uh, other speakers will deal with these topics in detail, but I will be concentrating on what I call woman-centric legal thinking and a woman-centric, rather legalist perspective. Now, in this particular context, I think it's very important to remember that feminist jurisprudence is something that we've not really been working on that hard. And it is time that we take feminist jurisprudence in right earnest. In feminist jurisprudence, we have two moral voices of law. One is the male moral voice of law, which builds on the notions of rights and justice, and the other is female moral voice of law, which builds on care and responsibility. Now, in an entire range of enactments, I think we need to remind ourselves again and again that woman centric legal thinking needs to take into account these perspectives. Um, there is something else that I would like to uh, emphasize, which is um, that gender justice, and by gender justice, I would imply women's justice here almost entirely, although there is the notion of men's justice, and I'm not really trying to deny that there could be cases where men's justice can also matter individually, but overwhelmingly, generally, overwhelmingly, and hugely rather, it is women's justice. And I would be using this women's justice coterminously with gender justice. Now, gender justice, I would say, stands at the crossroads of several civil society movements, social work experiments, and human service arrangements. And as a paralegal functionary who has been working in this field for about 3 decades now, if not a little more than that time span, I have been experiencing a whole lot of interesting, um, let me call them developments. And that is that in the interrelated fields of women's participation in legal matters and their access to justice, and at the same time, the notion of their legal empowerment would all be integrally connected with one another. And in this entire range of activities, it is the patriarchal biases and prejudices, male dominated, male chauvinistic biases and prejudices that would mar and spoil the healthy developments of pro woman legal endeavors. So, in this particular context, I would emphasize on the need for reconceptualization of categories under which crimes and offenses against women and girls are being recorded. Take, for instance, the NCRB data. It is the same old categories that we repeat and that we follow. So, in this particular context, there is need for recording violations in the areas of intimate partner uh, uh, connection, relationships. There is also the need to take into account the very important matter of women's unpaid work. Now, I don't know what innovative legislation could be enacted in these areas, but on a day such as this, we need to think aloud and think about these possibilities. Um, there is something else that I would also like to emphasize, which is that I've been doing a bit of academic legal research in the interrelated fields of trafficking, forced prostitution, and sex work. And in this research, which I've been doing for more than 2 decades now, two very interesting developments have been noticed. One is the very extensive and deep-seated family involvement in matters of trafficking. And from family involvement to involvement of uh, local panchayat functionaries and police personnel. So, when we consider anti-trafficking work and then we formulate projects, proposals, etc., we fail to take into account these matters. Um, so it's time that we do something about it, and we try and legitimize it as research problematics these extremely crucial uh, matters. Um, there's something else that needs to be highlighted in this context is that much of our anti-trafficking work really depends upon what we call the continuation of a particular narrative which builds on um, arrest, um, integration with families, etc., etc., rehabilitation, etc., etc. Now, if we take into account the twin matters of family involvement and the involvement of local panchayat functionaries and police personnel, we really need to broaden the entire gamut of what we need to do. So I think these are some of the matters that I wanted to highlight. And to end, let me just say that gender justice really stands uh, uh, at the crossroads of several academic disciplines, law, social and human sciences, and the humanities as well. And so, in academically as well as in civil society matters, we again need to broaden the, the gamut of thinking. And accordingly, we need to deepen our action plans, etc., etc. So I think, and this is about all that I really wanted to talk about. Thank you.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे